At the High Court Criminal Division in Kampala, only the accused Hajobedi Lutale and Captain Oya Oladenish appeared before court. Although retired Dr. Kizza was expected to appear in court today, he was absent. However, prison authorities presented Judge Emmanuel Baguma with a letter explaining the accused's health condition. Prosecution requested court to proceed with the hearing of the case in the absence of Dr. Kizza Besigye. The request was, however, opposed by the state brief lawyer Sylvia Namaweje on grounds that proceedings in the absence of the accused will violate his rights to fair hearing and that some defense lawyers were not present in court.
Assistant DPP. My Lord, it is true we have been availed with a copy of this letter from the prison, and we also still wish to inform court that we have a witness on the stand, and we want to make an application before this court, my Lord. And we are ready to proceed. We pray to be guided by this court.
Yesterday, I think it would be very important to establish the health situation of A1 before court can proceed. But most importantly, Article 28 of the Constitution that provides for a fair trial makes it a non-derogable right for an accused person to be present at his trial, except under very special circumstances. My Lord, I've had opportunity to look at the letter that is from Luzira, and it indicates that the accused person is not well. And in the circumstances, I pray that this honorable court is pleased to grant an adjournment to allow A1 to be present at his trial. My Lord, whatever application prosecution intends to lay before court is also part of the proceedings, and it ought to be made in the presence of the accused persons, in the presence of all the accused persons.
During the same court session, accused Hajobedi Lutale expressed concern over what he described as being forcibly represented by state brief lawyers.
Hetu, as I said yesterday in this court, that I don't fear to be tried, but what I want in this court or in this temple of justice is fairness. So I want it to be on record that as of now, I'm not represented, as the prosecutor said. I have not consented for anyone to represent me in this matter as of now. Thank you.
In his ruling, Judge Emmanuel Baguma directed prison authorities to present a detailed medical report on the health status of Dr. Kizza Besigye during the next court sitting.
I have listened to what prosecution has brought forth. I will proceed to make the following remarks and findings. That today, the two lawyers on state brief are not in court, as submitted by Council Namaweje. They are supposed to be three in the state brief, but today it's one who is in court. 2, the Zera prison has communicated that A1 is not able to attend court. The communication is on court file. For that reason, I directed that the Zera prison must avail the medical report informing this court the NSA status of A1 is not in court. I also inform Council Namaweji that informed the other 2 lawyers in the state to appear in court so that the prosecution will make the application which they have told the court in the presence of the accused persons and lawyers in the state next week Tuesday.
Due to the absence of Dr. Kiza Besigye, the hearing of the case could not proceed. Yesterday, Dr. Kiza Besigye collapsed in court while protesting the trial, urging that it was unfair and infringed on his constitutional right. Prosecution yesterday presented its first witness, Andrew Wilson Orlando, an American investigator. In a separate development, High Court Criminal Division, presided over by Judge David Matovu, declined to grant bail to lawyer Elias Lukwago. In rejecting the bail application, the court ruled that the accused had failed to demonstrate that his alleged deteriorating health condition could not be adequately managed by prison authorities.
Yes, in so many of the matters we've handled, there is no matters deserving a decision, positive decision, on conditions or circumstances that would warrant a grant of bail like the one of the Honorable Lukwago. Especially that the judge found that he satisfied all requirements or conditions that are precedent to being granted bail. So on matters of law, at least the judge was very clear that he satisfied all the grounds that are required, even in the regulations, leave alone the law. Save for one ground which we think he erred. He erred in using special circumstances to deny grant of bail. This is not a matter which required special circumstances to be proved for him to be granted bail. This is a matter which would ordinarily even be tried by the Chief Magistrate's Court, as was the case before the DPP exercised the right to determine which court can try him. So it is not such one matter where the judge would have gone to exceptional circumstances.
Court further observed that although Mulago National Referral Hospital had recommended the accused to receive further treatment from his primary specialist doctor in India, the recommendation was not supported by any medical report from Luzira Prison Health Authorities.
By requiring certification of the medical people at Makshon Bay that the Honorable Lukwago cannot be handled by Makshon Bay, that requirement was not necessary as a condition to deny him bail. So we think there he erred. But leave alone that. In granting bail, besides being a matter of law, the discretion has to be exercised judiciously. It was injudicious of the judge to even, in his opinion, think you need certification of Makshon Bay when the National Referral Hospital experts, 5 experts, made a finding that actually the Honorable Lukwago cannot be managed even at the National Referral Hospital of Mulago, leave alone Uganda, that experts in India are the ones who can handle his condition. And this is in a report which was requested by court or directed by court. So requiring the Honorable Lukwago to certify, finding that the Honorable Lukwago was required to have the report certified was also wrong, because this was a report of court. This report was directed by court in Machindi. So it was a report from the doctors to court. It was not a report from the doctors to Lukwago for him to be required to certify, or it to be certified by other doctors in Makshon Bay. So that was also an error of fact So he erred on matters of law, that in special circumstances may be required to prove that he's sick. He also erred at fact that the Honorable Lukwago required to certify such a document, which was not his, which was an official document to court. So on those grounds alone, having been the small issues that need to be corrected, we are going to review this decision and correct where court thinks we need, because it's not outside our reach. That he has directed that this file goes to another judge, still shall appear. We are going to ensure that we immediately push for this file to be placed before another judge, like he has directed in his decision, or push for session, because we know this is not a matter that can be sustained. So we are going to do everything under the sun. We take this matter as a life and death matter. The Honorable Lukwago is sick. He cannot be treated here. When we are fighting for a right to life, we are fighting for life. So there is no other right which is superior to the right of life. So we are going to fight with the energy, capacity that we have as a team. But to the extent that there may be political connotations, or that politics might have guided the decision or directed this decision, again, we are looking at it in that angle. We cannot isolate the fact that this is a political case. So we are also putting on political lenses, and together with the politicians, for the politician that he is, we are going to put our heads together to handle the matter, the politics in it politically, and the law in it legally, to ensure nothing but trying to preserve a life. The Honorable Lukwago's life is threatened by continued detention. Now, our team is already ahead of me. We decided that we have to confer with the Honorable Lukwago. You know, he's not an ordinary client. He's a lawyer. And in planning, in all these plans that I'm stating, in all the preparations, he needs to be involved. So we are going to consult him with a view to receiving the final instructions on the next course of action.
Lawyer Lukwago is charged with 1 count of misprision of treason and is waiting plea before a judge to be assigned by the Deputy Registrar.